Okay, dear students, welcome back again. Here we are in the course in bioethics in the Masters of Cell and Molecular Biology at St. Thomas University. Beginning always with a little prayer in the name of the Father, the Son, and the Holy Spirit. Come, Holy Spirit, fill the hearts of your faithful and enkindle in us the fire of your divine love. Amen. All right, as always, any questions or comments from previous lectures or anything you want to say or ask? Nothing? Okay. I can't believe I'm always so crystal clear in my teaching that no one ever asks a question, but I guess the topics are fairly basic. Once we get into them, I assume that a number of these topics you had never heard about before, but once we take the time to explore them and to explain them, then they're very understandable. But always within the context of a principled bioethics, in contrast to a utilitarian bioethics, which will use a different approach that I've talked about before. Anyway, today I want to talk about consent. Consent. All right, yeah, within the context of end-of-life issues and the whole issue of consent, and then advanced directives and what makes up the package of advanced directives, basically 3 basic documents. And then 2 more documents that are known for their acronyms, POLST and MOLST. All right, so we'll get there little by little. Just want to say as an introduction that consent is fairly recent in the history of medical practice, all right? For centuries and even millennia, the standard model of medical practice was what is known as paternalistic. In other words, doctor knows best. And what the patient, basically the patient only had to say 2 words, yes, doctor. All right, or if you want to amplify a little bit, whatever you say, doctor. Because the understanding was that the doctor knew more than the patient with regards to what's going on, at least health-wise, right? And that is still true to this day, because evidently not the vast majority of the population in whatever country, even the most advanced country in the world, doesn't go to medical school, right? If you look at percentage-wise, statistically, it's a very, very tiny percentage of the population of any nation that actually goes to medical school or is a healthcare professional. I mean, maybe even nursing or any other allied health professional, right? You lump all those together, healthcare professionals, and they're a relatively small percentage of the population of any given country, including the US. So the understanding was that the doctor really knew best, and that was it. However, this issue of consent started coming up when entire healthcare professions essentially got sequestered into, or hijacked into doing evil, all right? And I'm thinking specifically of almost a century ago, 1930s and 1940s, Nazi Germany, for example, the atrocities that were done in concentration camps, all right? And keep in mind that those experiments that were being done in the concentration camps, medically and scientifically, were almost impeccable, all right? They had very, very high rigorous standards as far as science is concerned, as far as the control groups, the placebos, and taking the data, recording the data, and so forth. What, of course, was missing, all right, was missing entirely was the consent of those victims that were being victimized, obviously without their consent, because no one in their right mind would have consented to the atrocities that were done in those concentration camps. And I'm not going to go into details. There's plenty of detail on the internet that you can look at. But basically, all that was done is within the realm of what is known as eugenics. All right, well, eugenics is the manipulation of the human population one way or another. And there are two types of eugenics, just to classify them, negative and positive eugenics. But those names don't really have to do with an ethical evaluation of eugenics, all right? It's not an ethical judgment such that positive eugenics would be something good to strive for. No, it's again, mostly out of a utilitarian mentality that negative eugenics is to eliminate defects, right? By eliminating the patient. In other words, even to this day, eugenics are going on. For example, in some of the Scandinavian countries, the government is actively trying to get rid of Down syndrome babies, Down syndrome children, right? To the point that they have, the government has created a mentality, a social mentality, whereby a mom who gives birth to a Down syndrome baby will be ostracized, beginning by her own family and the whole social network. How dare you bring to life or birth, give to birth this Down syndrome child, assuming that that syndrome child is going to suffer, okay? Which is a big, huge assumption. I can tell you from experience, I don't know if you know any Down syndrome children or people. One of my second cousins is a Down syndrome child. She's about 15 or 16, I think. I've told you about her. And she's totally mainstream in high school and everything else. And she's the joy of the family, all right? At any rate, that eugenics mentality also spilled into the US. Oh, sorry, before I get into that. So negative eugenics is to try to eliminate people who have birth defects, either before or after birth, all right? But because after birth, we have certain legal rights, positive rights that are protected by the Constitution, then the target is before birth, precisely, the unborn. And so the unborn, when you think about it biologically, the gestation is the highest form of protection, which only occurs in mammals, right? And of all the animals that exist on Earth, the offspring that have the highest form of protection biologically are the ones that are gestated, okay? Because even other vertebrates, for example, egg-laying vertebrates, fish, amphibians, reptiles, birds, those eggs can get eaten up, crushed up, etc. But the mammals have developed the most complex and the most protective environment for the embryonic stage until that embryo or fetus comes to viability, when they can survive outside of the womb in the environment. Also in the wild, it's interesting to see that many wild mammals, once they're born, they need to hit the ground literally with the boots on, all right? In the African savanna, for example, and so forth, when a baby giraffe is born, that giraffe needs to start running because the lion is not far away. And it's natural selection. The baby giraffe, just newborn, that doesn't hit the ground running will get selected out, and the weakest. So it's a natural selection process. Anyway, whereas biologically in nature, it is the most secure place to be, is the womb, because of the legalization of abortion up until the 9th month, as we know, not only United States, but many parts of the world, mostly in developed countries, okay, then it's the most dangerous place to be. It's actually the most dangerous place to be because there are no protections, okay, and they're targeted, and this eugenics movement has not gone away, and it's around. I can give you an example in the Netherlands. Then we're going to see a little further on in this course, in a few lectures, that eugenics movement has also gone into the end of life. So essentially, the weakest are being targeted. all right? The weakest in our population, whether they're on board or they are elderly or frail, they're being targeted to be selected out. And that's essentially a eugenics mentality, which is what technically is called negative eugenics, all right? Positive eugenics is genetic engineering, is to enhance, it's enhancement, genetic engineering on the embryos. Yeah, what this Dr. He did, H-E, in China to genetically engineer these two baby girls. They're known as Lulu and Nana. You can, the Chinese have some kind of a fixation for generating these names that are double consonants, double syllables. So Lulu and Nana, you can look it up online, and they were engineered at the zygote level to be immune, supposedly, to HIV. So for example, how do you test for that, right? You infect them with HIV to see if they're really immune or not. So it's just totally sick. Anyway, that is technically what is known as positive eugenics. So all for the betterment of society, right? Well, we have seen that the middle of last century, the eugenics that was going on in the 30s and the 40s in Europe, and that spilled over into the US, eventually led to a world war, to the Second World War, because the madman had to be stopped. He had essentially taken over Europe, and he was spilling into North Africa. And I think did I tell you about the submarines, the U-boats on the coast of the eastern coast of the US? Did I ever tell you about that?
I don't think so.
Oh, okay. I get going on this tangent, but I think it's important for you people, the young people, to know if you're living in South Florida. I don't know if you've ever been to the zoo. It used to be Metro Zoo. Now I think it's called Zoo Miami, down in the southern part of Dade County, close to Homestead. Anyway, there's a big, huge tower there in the middle of the parking lot, and it's just a concrete tower. And I haven't been there in a long time, but it basically is just empty. There used to be a docking station for blimps, you know, like the Goodyear blimp that you see on top of the stadium when there's a game, right? So those blimps are very quiet, very silent. And the eastern coast of the US had these stations along the way. There's one also, one of those towers down in the Keys. I think it's toward southern part of Key Largo. I think now it's being used as a relay station for microwave or something, cell phones, transmission, retransmission. Anyway, those big towers, there were docking stations for blimps that used to patrol the eastern seaboard. And why was the eastern seaboard of the US being patrolled in the 40s? Because intelligence, Allied force intelligence had already gotten evidence that Nazi Germany had developed submarines that were finding a landing site on the eastern seaboard of the United States to invade the United States, That's now documented. You can go online. It's been declassified. There's evidence that there were U-boats, Nazi Germany, submarines that got as far in as Hudson Bay, looking with a periscope at Manhattan, all right? And down here in the coast also, they were looking for an area that was nice and quiet where they would not be spotted. Okay, maybe in the Carolinas somewhere, the Outer Banks, that area where they could land and essentially invade the US. And it would have been a very pointed strategic invasion, probably heading toward DC, Washington, DC. And this sounds pure science fiction, but that was in the works. The man was absolutely insane. But in that insanity, he got a whole nation, millions of people to go with him, all right? Anyway, So after the Second World War, in the 1940s, I think it was 1945, 46, was the Nuremberg Trial. And the Nuremberg Trial was precisely to judge those who the Allied forces were able to trap, because supposedly Hitler committed suicide, so he couldn't be tried. But then many of his generals and officers that were running the concentration camps, high officials, all right, that had a say in the atrocious treatment of these human beings, were put to trial. Those that did not escape to South America or somewhere else. And after that, there was a code. There was a code called the Nuremberg Code. And it's about 10 points, all right? And it's all about precisely consent. In other words, that going forward, you know, the dignity of the human person is such that it has to be protected, all right, and not trampled on. And then there was another accord shortly after that. It's known as the Helsinki Accord. You can look it up. But basically, now we have gone almost from 0 to 100 here with regards to consent in about half a century, a little bit more than half a century. But before then, for millennia, basically, whoever was in the practice of medicine, or even a shaman, whoever it was the one who dictated what was best for the patient and the population at large. So it's important we dedicate at least one lecture to this. And moving forward, I'm going to be using the ERDs as a basic little document here because it's very succinct. The ERDs themselves, they have 6 ERDs that are dedicated to consent. So then just before the class, I did a little percentage just quickly. It turns out that the 6th edition of the ERDs, right, the 6th edition has 77 directives, total of 77. So I just quickly did a little math and it comes to about 8%. These are 4 are here and then 2 more that have to do with proxy consent, all right? So the first 4 ERDs that I'm going to talk about have to do with informed consent, free and informed consent. And the last 2 have to do with proxy consent, assigning a surrogate or someone to speak on our behalf. And those 6 come to about 8%. So 8% of the whole document is dedicated just to consent, one way or another, all right, different aspects. So that's pretty significant, because all the other topics are distributed in the other 71 directives. Okay, and they come from mostly 2 parts. Remember how the directives are divided into 6 parts, right? And the 2 main parts where consent comes from, the directives, are in part 3, which is the doctor-patient relationship, right? Very understandable, doctor-patient relationship. And then the other, so they're in their 20s, the numbers in the 20s, and the numbers in the 50s and 60s are for end of life, the part on end of life, okay? So again, it makes sense as the internal structure. So let's look at these 4 first, which have to do with concerned when the individual, when the patient is still sound of mind, all right, and can make her or his own decisions. Number 28, and I'm not doing them sequentially in the original number. I'm going kind of backwards, 28, 27, 26, and then I jump to end of life. And the last 2 that I say have to do with proxy consent are actually numbers 25 and 24. So I'm going kind of backwards. To me, they make more sense logically this way, all right? You can decide later, but this is how I'm going to present it. So beginning with ERD number 28, each person or the person's surrogate should have access to medical and moral information and counseling so as to be able to form his or her conscience. The free and informed healthcare decision of the person or the person's surrogate is to be followed so long as it does not contradict Catholic principles. Okay, let me start from the end here, just a clarification. You can interpret Catholic principles as essentially principled bioethics. Principled bioethics, where we hold the dignity of human life from conception to natural death, all right, and all of the consequences that that has. Now, so this one is mostly the patient's rights, all right, the patient's rights to have access to information that is necessary for forming the conscience, right? Remember, the root word of conscience comes from the Latin, cum scientia, science or knowledge, and con or cum in Latin, with knowledge. So if I don't get the knowledge because I didn't go to medical school, then I cannot form my conscience, all right? And therefore, I have a right to have that medical information, okay? And also moral information here is interpreted in the bioethical information. In other words, information, moral information that has to do with healthcare. All right. Then the next one is kind of the flip side of this. So this is the right of the patient to have access to information with regards to their own. They're very clear about this, not someone else's medical information, right? Because that's protected by HIPAA, but to my own medical information. I have a right to my own medical information from whoever, if it's an individual doctor or if it's an institution like a hospital, a nursing home that is taking care of me. All right, 27, free and informed consent requires that the person or the person surrogate receive all reasonable information about the essential nature of the proposed treatment and its benefits, its risks, side effects, consequences, and cost, and any reasonable and morally legitimate alternatives, including no treatment at all. So this one is on behalf of the medical profession or the institution, the healthcare institution. They have a duty to provide that information, okay? So the patient has a right to receive the information, and the healthcare outfit, whether it's an individual doctor or nurse, or typically the doctor, or the institution as such, hospital, nursing home, skilled facility, has the duty to provide the information, okay? Reasonable information. Of course, there's also confidential information. For example, how much does the hospital charge for an aspirin? That may be confidential. That would be privileged information of the hospital, you know, whatever market economy, but that's not relevant information for the well-being of the patient. All right, so we have to be clear here that it's reasonable information, and therefore the patient should not be demanding information also that is kind of irrelevant to their healthcare. All right, moving along. All of this is pretty intuitive, I think, once we look at it, but we need to go through it anyway. All right, number 26. Free and informed consent of the person or person surrogate is required for medical treatments and procedures, except in an emergency situation, when consent cannot be obtained and there is no indication that the patient would refuse consent to the treatment. So you think of the ER, the emergency room, a patient presents and they're bleeding, they're unconscious. Well, that's the medical staff is going to intervene right away, assuming that the patient wants to be healed. All right, so the assumption here is in favor of healing. But then once they open up the person, they see that the patient has a sign here, do not give me a blood transfusion or hands off or DNR, all right? So if there is no evidence, no indication that the patient doesn't want treatment, then the assumption is that they do want the treatment. So this one covers emergency situations, and it also those ERs have legal protection also. It's part of their liability exclusion or whatever that they're going to intervene, unless there is some explicit evidence that the patient doesn't want to be treated for whatever they're hurting. Okay, and then finally one on from the end of life itself, number 59. The free and informed judgment made by a competent adult patient concerning the use or withdrawal of life-sustaining procedures should always be respected and normally complied with, unless it is contrary, again, to Catholic moral teaching or principle bioethics, basically, like I mentioned. So if you think about this one a little bit, how is it different from the others? Well, it's kind of a subset, because this one is with regards to use or withdrawal of life-sustaining treatments, okay? The other ones applies to healthcare in general. The other ones apply to healthcare in general, but this one is to end-of-life issues, all right? The person may be dying from something, and so that's why it's in section, in the third, in the part number 5, which is end-of-life issues. All right, any questions then as to, see, that makes consent free and informed. Free and informed. How can a patient give free and informed consent if they're not told what's going on? Today's context is pretty clear, but it wasn't always this way. Okay, if no questions, then I'm going to move forward with two ERDs that have to do with proxy consent. And then the rest of the lecture pretty much is going to be looking at a lot of the proxy issue. So there are several words that are interchangeable here: proxy, surrogate, agent. Each one has a little slightly different connotation, but for our purposes, they're kind of interchangeable. So number 25, ERD 25, each person may identify in advance a representative to make healthcare decisions as his or her surrogate in the event that a person loses the capacity to make healthcare decisions. Decisions by the designated surrogate should be faithful to Catholic moral principles and to the person's intentions and values, or if the person's intentions are unknown, to the person's best interest. This person here is the patient, not the surrogate, all right? In the event that an advance directive is not executed, those who are in a position to know best the patient's wishes, usually family members and loved ones, should participate in the treatment decisions for the person who has lost the capacity to make healthcare decisions. So again, I want to put here, proxy can also be known as a surrogate, as the, I'm just going to put equal. More or less equal, all right, for our purposes, representative. And another one you'll see is agent. I don't have the more or less equal sign with me, but this equal interpreted as more or less equal. For our purposes, it's kind of the same, because you run around this across these different words in depending on the context, if it's more medical or more legal. Finally, ERD number 24, in compliance with federal law, a Catholic healthcare institution will make available to patients information about their rights under the laws of their state to make an advance directive for their medical treatment. The institution, however, will not honor an advance directive that is contrary to Catholic teaching. If the advance directive conflicts with Catholic teaching, an explanation should be provided as to why the directive cannot be honored. All right, so here there is the introduction of this advance directive, which is a technical term. And as I mentioned, it's a little package that contains generally 3 documents. And we're going to go through those 3 documents in a minute. But this one is addressing the fact that the patient has a right to have advance directives, and that those advance directives in principle should be honored by the healthcare institution, unless in this case, if it's a Catholic institution and there are instructions there in these directives, there are instructions that are offensive to Catholic teaching, then of course the institution cannot honor those, all right? So basically, this one has to do with advanced directives. Again, any questions there? So let's look at simultaneously the topic of proxy or surrogate or representative in the context of advanced directives, because that's why they are, there's this little package. Oh yes, a little bit on the legal side, just before we go more on the medical issue of advanced directives, okay? Just pointing out here, because these documents, these advanced directives, have to navigate in both waters, in the medical waters and in the legal waters, all right, in order for them to be really effective and meaningful. Let me ask just quickly, how many of you have actually heard about advanced directives? Have you all heard about advanced directives? At least heard about them? Let's see. Let me just pull up the file here. Okay. Let's see, just by a show of hands, how many of you have heard of advanced directives? Yeah. Okay, good. All right, and let's see. Juliet, Alisa, Onome, maybe off screen.
No,
Okay. All right. So yeah, advanced directives. Have you covered this in any other course?
no.
You have not covered it in any other course, huh? Okay, well, we're going to cover it now. Okay, so here we go. First, on the legal side, there are 3 conditions or constraints, limitations for a person to be a proxy, okay? And the whole issue of designating or assigning or choosing a representative, someone who will represent us. Obviously, the issue is that we are unable to represent ourselves. We may be unconscious, we may be in coma, we may be demented with senile dementia, or temporarily incapacitated, a number of things, okay? So 3 fundamental constraints is the person making the delegation must have the right to consent. These look kind of obvious, but I'm going to give you examples of each where you'll see it more clearly how it applies. So the person making the delegation must have the right to consent. This refers to the patient. In the context of healthcare, the patient must have the right to consent, all right? For example, a situation where someone may have lost some of their rights. Okay, these are interpreted not as natural rights or human rights, but these could be interpreted as legal rights or what is known as positive rights. For example, some inmates may have constraints on their delegation. Okay. Because they're incarcerated, they're in prison, and some of their rights have been restrained. So that's an example. It's kind of extreme, but it happens. Number 2, a person must be legally and medically competent to delegate the right to consent. Again, this seems pretty obvious, but I'll give you an example. For example, people who are undocumented. If they're undocumented, they may not have the legal right to consent, all right? They may not have the legal right because they don't have a legal status in the country. Number 3, The right to consent must be delegated on a legally and medically competent adult. So by default, underage children cannot be proxies or representatives. Is too heavy a burden, all right? At least legally. Sometimes de facto children or teenagers have to take responsibilities for loved ones, but at least legally it has to be an adult. Also, for example, that adult has to be legally and mentally competent. So for example, we would not use as a proxy or as a representative a person with Down syndrome, an adult with Down syndrome, or an elderly person who has already some manifestation of senile dementia or Alzheimer's, even though generally older people are supposed to be more wise than younger people, right? So in delicate healthcare decisions, you would want to have a very wise person represent you. But sometimes if that person is mentally incompetent, then that person cannot be a proxy. But this is more on the legal side of things. I'm going to shift back to the more medical healthcare. And these are some characteristics of advanced directives. Like I said, there are three. We'll get to them in a minute. But before, just some more background about advanced directives. First of all, they're written instructions. So it's something in writing, right? These are documents in writing. Regarding medical care, when unable to speak on one's own behalf with regards to healthcare decisions. So for some reason, we, the patients, are incompetent. We're not able to speak. It could be a number of issues. They could be physical issues, they could be psychological issues, or a combination. Okay. Then these are a very good guide for one's family and doctors to know what is our preference with regards to treatment. For example, well, we'll get to some examples in a minute. But this is a very, very good guide for our loved ones and our healthcare professionals, especially when there are borderline issues, all right? Should we intubate or not? Should we extubate or not? And if there's some written document, that's a big relief for everyone concerned. So the next one is kind of begging the question. It follows up. Confusion and disagreement are minimized when there are advanced directives. And finally, they are generally legally binding. They are. Even if they're not registered in the court. So of the three documents, only one really needs to be registered in the court. The other two don't need to be registered, and they're still generally, they're legally binding. So these are the three here. Advanced directives, living will, a power of attorney, which is a particular power of attorney, not a general power of attorney. And then the do not resuscitate order, which is normally known as a DNR. All right, so living will, a power of attorney, and a DNR. Let's look at each one by one. Now, for the living will, again, going back and forth between utilitarian and principled bioethics, I can tell you that there are many, many living wills out there. And many, many of them are basically utilitarian, and they just give absolute right to the patient, to the individual to decide whatever they want to do. All right. They go too far. They go too far because, again, the vast majority of the population does not have a medical background. And so if you give absolute autonomy to patients, then you end up putting the cart before the horse. In other words, you end up the patient telling the doctor what to do and what not to do with regards to healthcare. Okay, but most patients don't prescribe, for example, unless they are actually a doctor or a nurse practitioner. Okay. Well, anyway, what I'm trying to say here is that, at least for this course, since I'm teaching it out of the principal bioethics perspective, then I'm going to show you what is a living will that is a principal living will from the Catholic Church. All right. Now, this living will is available to anyone who wants to use it. They don't have to be Catholic. Anyone can use this will if they want to. They don't have to be Catholic. They don't even have to be believers. But once you start reading the document, you see that it's a very comprehensive and solid document. So we call it a Catholic Declaration of Life and Death. It has this specific title, all right? It is a Catholic living will, Catholic Declaration on Life and Death, and it's both an advance directive and a designation of surrogate or proxy. It's both. One side, it's a single sheet of paper. One side is the directive, and on the reverse side is a designation of proxy. All right, so it's on a website that everyone can access. It's called the Florida Conference of Catholic Bishops. You notice that it's anchored by the state. Each state in the union has a conference of Catholic bishops, and this conference is made up of the bishops of the region. So for example, in the state of Florida, all right, the state of Florida, there are 7 dioceses. Miami is one of the 7 dioceses, what is known as the Archdiocese of Miami. It's known as the Archdiocese simply because it has the highest density of Catholics living in the area. But also, even though it's named Archdiocese of Miami, it actually includes 3 counties. It includes Dade County, it includes Broward County, and it includes Monroe County, which is the Keys, the Florida Keys. So it's pretty large territory, all right? And that is the Archdiocese of Miami, one of the 7 dioceses. So this Florida Conference of Catholic Bishops is an office that is in Tallahassee, and it's essentially like a lobby group that is petitioning the legislature for Catholic issues. And the Catholic issues can be either in healthcare or in education, for example, as in vouchers for private schools, private school vouchers, and so forth. And this is kind of a clearinghouse, this office that is in Tallahassee. For many of these documents, they're on the website and they can be downloaded for free in English or in Spanish. And here is the website, okay? So you can punch that in. I have them already downloaded, so let me go there for a moment. And it is, which one? Here, Declaration of Life and Death. So you have it, I posted it already in the, I posted it in module 8 of the Canvas. Let's just take a look here for a moment. Smaller. All right, so this is the front part, which is actually the designation of the surrogate, as you can see here. Okay. And then the reverse is actually maybe didn't download the whole thing. Well, let me go to Canvas for a moment. I can open it there. So it starts with a brief introduction, just stating our beliefs, all right? Stating the belief that the person, the patient, whoever is signing this declaration, believes essentially in eternal life, and basically that we're passing through here, but this is not the end all and be all, and therefore that statement of belief helps other people understand that we accept that sooner or later we're going to die, all right, and that our call really is to live eternally with God, and therefore that we accept death. We're not against us dying, but at the same time that we make a distinction essentially between allowing us to die, reject life-prolonging procedures, all right, that are futile, but that should not be interpreted as a right to kill myself or for other ones to kill me. Okay, so it's very upfront here, making that critical distinction between allowing a person to die or killing that person. We'll get more into it. We'll have a whole lecture on physician-assisted suicide and euthanasia, but that's stated upfront. Then, straight away, the designation of the surrogate or proxy or representative. In fact, two for lack of one. There's a primary, which is here, name, address of the proxy, and then as many phone numbers as one can find for that person. Typically, the one that works today is a cell phone. At any rate, that information here, and then doesn't have to be, but if one wants to assign a second surrogate, an alternate surrogate, then there's room for a second one. Like the little statement says here, if the first surrogate is either unwilling or unable to be available at the time, because we never know when we're going to need that surrogate, right? It's not that, oh yes, tomorrow at 4:30 p.m. I'm going to go unconscious. No. So we never know, and therefore it's a good practice to assign an alternate, because my first surrogate may have either died or gone on vacation and is not available at the moment that we need them. All right, so two surrogates, but the second one is not necessary for the document to still be valid. Moving forward, it is here. Okay, so this is the actual living will or the declaration, and it gives instruction. It gives guidance as to what I would like to have done or not done in case that I cannot speak for myself. Care and comfort, which we talk about, distinct from cure. Even if there's no cure, this assumes that there's no more cure available. All right, so care and comfort. We'll talk about basic care and comfort. No inappropriate or excessively burdensome or disproportionate means should be used to prolong my life. All right, so these are extraordinary means of life support. There should be a presumption in favor of nutrition and hydration. We're going to devote another lecture to nutrition and hydration also, because this is a crucial one. Nutrition and hydration is like a subset, all right? And in principle, nutrition and hydration are ordinary means of life support, in principle, but there are exceptions. So in principle, nutrition and hydration fall under care and not cure, even when there is no care, because in normal life, we nourish ourselves as part of care. Okay? We're not curing anything, we're just living, we're metabolizing. So nutrition and hydration in principle should be provided for, including medically assisted nutrition and hydration. And these are the two exceptions here, which we'll cover in greater detail when we look at a particular case of PVS and a PEG. So assisted nutrition and hydration would be, for example, an IV, intravenous, is being provided artificially, but the fact that it's being provided artificially, right? Because we normally, naturally don't drink water through our veins, okay? But an IV is going precisely into intravenous, right, into our bloodstream, providing nutrition and hydration. And therefore it's artificial, but the fact that it's artificial doesn't mean necessarily that it is extraordinary, very important. Okay? So these are the two exceptions. It cannot be reasonably expected to prolong my life, or the means that are being used are excessively burdensome to the patient, again, to the patient, or not sufficiently beneficial to the patient. And those are the exceptions. Okay. We'll talk about them a little bit more when we get to nutrition and hydration precisely, but it's part of the document, as you can see. This number 4 refers to physician-assisted suicide or euthanasia. Nothing should be done with the intention to cause my death. See, the emphasis is on the intention. If there was every possible intervention and the patient still died, well, it was not the intention of the healthcare professional to kill the patient. They were trying to heal the patient, but they didn't succeed. But the intention is what is not accepted here, the intention to cause the death. And finally, the spiritual care is very important, especially when there is no more cure, when medicine can no longer do anything for me, physiologically or even psychologically. The spiritual dimension should always be taken care of, right? Depending on whatever faith, religion the person has. It doesn't have to be Catholic. They don't even have to be Christian. They can be, if they're Muslims, to get them an imam, you know, to minister to their spiritual beliefs. If it's a Jewish person, to try to get a rabbi, etc. So the spiritual dimension should always be taken into account in the patient, looking at what we call the holistic view of the human person. Holistic, H-O-L-I, holistic meaning the whole person, body, mind, and soul one, all right? The whole idea that we are body and soul one, and the soul also needs to be taken care of, especially when we are delicate like that, we are close to death. Well, I can tell you from experience, being a priest for 35 years, this dimension is a very, very important one toward the end of anyone's life. Additional instructions if the person wants, but not necessarily to put anything there. Then finally, the signatures, the declarant, which is the person, the patient, if you will, all right? The person who is making this declaration, the date, the last 4 of the social, and then 2 witnesses, and the witnesses, they're just witnessing the signature. They're witnessing the fact that the person writing the declaration is in fact that person, and they're not faking to be someone else, all right? So typically these 2 witnesses are people who are known to the patient, but they should not be the surrogate. They should not be the surrogate or the alternative surrogate, all right? So you can see it's a very useful document, and I promote it especially for older persons. So for example, your parents or your grandparents, if your grandparents are living, these are the people who want to look at a document like this. And like I say, they don't have to be Catholic, they don't have to be Christian, but it helps a lot. Even they don't have to be believers. If they just want to assign someone to represent them, then they use this part of it, okay? And it's a very, very useful document to have. So you people are young, and hopefully we talk about the fact that sooner or later we're gonna die, right? And hopefully for all of you, it's gonna be later, much, much later. But you can also have one of these. You can also fill out one of these if you want. And then what you do is you copy it. Once you fill it out, you copy it front and back, and then you farm it out to the people who you love and the people who love you, because no sense writing this document and then putting it under the mattress, right? Because at the moment, the critical moment, they may not look under the mattress. So you want to give it to your doctor, to your healthcare professional. You want to give it, if you have a lawyer, you give it to the lawyer, goes on your file. You give it to your parents, you give it to, if you're married, to your spouse, etc. So you farm it out to the important people in your life. Of course, I forgot to mention the obvious, which is when you select a surrogate or a proxy, you obviously need to consult with them and ask them, right, if they want to be proxy or not. And on this note, I want to say the following. Sometimes people feel intimidated to be a proxy, all right, or a surrogate, because they don't know. They have to make the decision to intubate or extubate, for example, which is one of the toughest ones. And they don't know, they're not doctors, they feel intimidated. But you say, look, you don't have to know all the clinical aspects of the thing. I'm not expecting you to know the clinical aspects, but rather to represent me, because I trust in your judgment, and I trust that you would do what I would have wanted to be done or not done. And that's on the reverse side of this document, right? But it's very important for the surrogates to know that they're not alone. They don't live in an island. They're actually connected. And as long as they have either a phone or internet, they can connect with the people who are in the know. So they can connect, for example, if you're using this Catholic Declaration, they can connect with the Florida Catholic Conference. Where's that little slide? Let me go to the slide for a moment. Okay, they can go to this website and there's a phone number there. They can call up people who know, they're bioethicists, they know. They can call me. In other words, there are people that they can call if they need help in deciding the critical moment when it's needed. Okay, so it's very important when you're selecting a proxy or you're trying to convince your parents or your grandparents to select a proxy, to fill one of these out, to let that other person know they don't have to know all of the medicine behind potential treatments and things like that. They just need to be able to communicate with experts that who will help them walk through. And I can tell you, in my decades of being in bioethics, I have walked many, many people through the steps of some very difficult, challenging decisions that have to be made. Okay. All right. So that's the Declaration of Life and Death. It's available, like I said, in Spanish and in English. And in fact, the document itself also comes, if you go to that website, there's another document there that is an explanation, pretty much what I've been talking about. It's an actual explanation of the document, phrase by phrase, paragraph by paragraph. Okay, and like I say, it's both in Spanish and in English for free to download it. So go ahead and disseminate it. Talk to your family members about this, talk to your loved ones about it, okay? Like they say, have the conversation. Have the conversation where you're very clear and lucid of mind of what you want done, what you don't want done. And I'll give you an example. We're gonna talk about Terry Schiavo, we'll talk about in the context of nutrition and hydration, and she was in her 20s when she collapsed in the middle of the night, all right? And went into coma, went into vegetative state for another 20 years. And the horrible mess that that generated because there was no document. And there was a discrepancy on her wishes between her husband and her parents. Everybody loved her, but in different ways. Okay, so power of attorney. Now it's a particular, I mentioned it's a particular type, and it's a durable power of attorney, known as a durable POA. And in general, a power of attorney is a legal document that designates an individual, and here they're using agent or proxy as the official terminology, to make medical decisions in the event that one is unable to make those decisions. for a number of reasons that we already talked about. But I keep mentioning it's a particular type of power of attorney. It's not a general type of power of attorney. It's one that is called durable, all right? And durable means that it actually kicks in when the person is mentally incapacitated. And that mental incapacitation, again, I emphasize, could be either temporary or permanent. All right, an example of temporary could be a coma, right? The Glasgow scale, remember? And the normal window is between 3 to 6 months before, if the person continues in a coma beyond 6 months, generally it will be declared in PVS. And we looked at those different states with MRIs and everything else. But that could be temporary. In fact, I just saw it on the BBC this morning. Let me see if I find the article again. There was a lady in Italy who was in coma, actually PVS, for 10 years, and she woke up. And there's a picture of her there smiling and totally conscious. So I did not read the details of the article, just saw the headlines. But you know, the more we know about nature, the less we know. Okay, 10 years in a coma, and she woke up. So when the person is incapacitated, that is when this particular type of POA kicks in. And that's why it's called durable, precisely. A normal POA stops when a person becomes incapacitated, all right? Because a normal POA typically has to do with mostly financial things and material goods like inheritance, but also bank accounts. So sometimes people assign a proxy or agent to represent them to run their business or to do some legal thing. For example, if you have investments, you may delegate an agent or a proxy to manage those investments. But you're perfectly capable and alert and alive, all right? But you just don't want to take care of those, of that management because you don't have the competence or the time, or you just don't want to do it. So you assign a proxy or an agent and you give them a power of attorney. They decide for you on the legal matters and on the financial, fiscal matters. Okay. But this one is different. This one is when we're actually incompetent. That's when it kicks in. And a normal POA stops when the person becomes incompetent. All right. Because the presumption there is that this agent or proxy with a normal PA is in consultation with you of what you want to do with your material things. All right, and the other aspect is that it's recorded in the court. So this one is very, very legal, if you will. It's hardcore, and it has legal implications. It has to be obeyed. All right, it has to be obeyed, whatever is in that durable POA. Okay, let me show you some examples before we go into the DNR. And each state has its own durable POA. Let me see, here it is. So here's one for the state of Florida. Precisely because it is a legal document, it has to have certain requirements. So one fills in the county, the particular county, because you know, there are national laws, there are state laws, and there are county laws also, okay? Or county regulations. And so it has to apply to this particular county, wherever one is living. So, you know, right away, the terminology gets into what they call legalese. Know all men by these presents. That's very legalese language, okay? We would say in inclusive language, know all men and women by these presents, right? And in just common parlance, we would say you all you all, this is for everybody to hear and heed that I, blah, 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 and fill out all the blanks there, authorize and appoint. So here goes the proxy or the agent. So the first name is the patient or the person delegating. And the second name is the delegee, the one who is receiving delegation. And then it continues with the legalese language, so on and so forth. There are about 10 points here. You can see most of them are material things, material goods, possessions, bank accounts, payments, collections, et cetera. But the one I'm focusing on is actually the 10th one, which is health, healthcare. Okay, so that's the one we're concerned with in this course. But last but not the least is the one on health. Oh, there's one after that, general powers, yeah. But this one on health, all right? And you can see that it has several points. I'm not gonna read the whole thing here out loud. You can take a look. But, oh, it's beyond the time already. Started, no, we're going to 3:30, right? Yeah, 3:30, okay, good. Still got 10 minutes. All right, so you'll see embedded in here periodically, should I fail to make a declaration? So you'll see that there's reference that I am incapable of making a declaration or healthcare decisions. Okay, and so that's the whole point there. But this document covers the patient when they are incapable of making those decisions. So a proxy, a surrogate. But this is a little bit more on the legal side. The other one, the living will, is a little bit more on the medical side, and especially it involves family members or the surrogates. The typical, who do you think is the typical proxy or agent in a power of attorney? Many times this person is an attorney, okay, it's an attorney. So again, some families have their own attorney to take care of their things. So that's typically the one who is assigned here. So it doesn't have to be the same as a proxy or surrogate of the living will, but it can be. But typically this one is an attorney. And again, signed, witness, but then the added part here, of course, is the registering in the courts, which means that it requires a notary public. And here's the segment for the notary public way down here. Okay. Okay, so moving forward then, this is the second one. The third, as I spoke, is the do not resuscitate order, which is also known as DNR. DNR, this is very much on the clinical side, but it also has legal implications. Okay, so this is legally binding, but it's a DNR form, which is essentially a medical instruction, which is to not resuscitate the person. In other words, do not apply cardiopulmonary resuscitation. Do not do CPR. Okay, do not do CPR, and this is the DNR order. Also, it clarifies here that the DNR order can also be a standalone, doesn't need the other two, doesn't need a living will, doesn't need a POA to be effective. All right, and one can also have the other two or any one of them without having a DNR. So the ideal package of advanced directives is all three, but any one of them can also be a standalone, and they're still advanced directives. All right, back to the DNR. Let's look at one for Florida again, because the first thing that you notice is that it has to be in yellow. Yes, the color of the form in particular. in order for it to be legal in the state of Florida, it has to be in yellow paper. Okay, so see, it's from the Department of Health officially. And again, you can download it and print it, but when you print it, make sure that you're printing on yellow paper. And it's got a front and a back. It's a sheet with 2 pages, front and back. No, I'm sorry, it's only 1 page. Only 1 page, one side. Yeah, because this bottom part can be cut out. Okay, let's go through it first. Of course, the first thing is the name of the patient, and then the date when the form is filled out. Okay, and then who you're assigning. And here it makes a distinction between these. It's either a surrogate or a guardian, a proxy, or a durable power of attorney, because these have legal implications, chapters on the Florida statute. FS is Florida statute, basically the laws of the state of Florida. And then signature here, and name. This is, again, the patient signing. This is the patient. Then the physician also signs down here, prints name, and puts the license of the doctor, license number. So you can see it's pretty official. And then this bottom part is essentially the same as the top, but in miniature, so it can cut out here. And this can be put in your wallet or your purse or something like that, where you carry it with you. Okay, so the big form is again farmed out. This one is photocopied and given to significant people, particularly the doctor, if we have a doctor that follows us, a regular doctor. And then this one, the bottom part, we can carry with us. All right. Now the DNR, we have to be careful because the DNR, generally, especially for young people, should not be filled out. Okay. Should not be filled out because the expectation is that if your heart stops, you can be revived. And you have a good, in principle, you have a positive, good positive prognosis. Okay. Give you a drastic example. One time, there could be a baseball game, and who's the most, who's the player who is at greatest risk in a baseball game? Anybody know? Who's the player who is at greatest risk to his or her health? Baseball or
Maybe the catcher?
not the catcher, because the catcher has extra protection.
The pitcher?
Or her, right?
Oh,
the catcher looks
batter.
armored, like an armored guy.
Yeah, that's true.
Even the glove is much
Yeah.
thicker. It's actually the pitcher, because the pitcher is standing in front of the batter, not behind the
Ooh.
batter. So
Nice.
the catcher only has to receive the pitcher's pitch, but the pitcher has to receive the batter's batting. What happens, and it's a very short distance at a very high speed, especially baseball, because it's hardball. No, it's not softball, it's hardball. I can say we're going to play hardball. And sometimes it's happened that a straight hit to the pitcher can hit him in the chest and can stop the heart. And it has happened. And all of a sudden, the pitcher is lying on the mound, paralyzed, unconscious, with a paralyzed heart. Okay, drastic, but it has happened. And what's the immediate reaction? CPR, because you assume that the pitcher is a relatively young person who is healthy. He or she is the pitcher, okay? So they're athletes and the heart just stopped. So there's a very good chance that if you get that heart started up again, that person will live, okay? Maybe sore for a while, but there's a very good prognosis, okay? So that's one example of definitely the picture should not have a DNR. Very different from a 90-year-old who has all kinds of comorbidities. I'm stacking the deck, as they say, of course, but a 90-year-old who's diabetic and has, I don't know what you want to throw in there, has high blood pressure and emphysema and senile dementia, and the heart stops. What's the compassionate thing to do is to let the heart stop, let the person go, right? You know, and do a very aggressive intervention of that person, because that heart of the 90-year-old, we can say pretty much gave up. That was it. So for that person, it's a good thing to have a DNR, because if the rescue team comes in, first responder, someone called 911, and first responders are knocking down the door because this person lived alone, and they see this person lying on the floor, and they don't see a DNR, they don't see anything, they're gonna try to revive the person, okay? All right, so it really depends a lot on patient by patient. But the DNR order, you'll see it in hospitals, and sometimes it's posted on the bed. Now, behind the bed. Now, what they post behind the bed is actually it's NPO, nothing per oral, nothing. Well, we'll cover that when we get to nutrition and hydration. But the DNR goes into the medical record of the patient, goes into the medical record, okay? And so a physician that is just coming on board to look at this patient, this particular patient, and is not familiar with the patient, they'll go to the medical record first before they go to the room and become familiar with the medical record, especially see if there's a DNR order there in place. All right, finally, yes, these two cases of pulse and MOLST have come up precisely almost as a pushback from the patient consent or patient autonomy. That's another word that you hear nowadays, patient autonomy, right? Well, it has to be reasonable autonomy. Very important, the adjective, we get it about autonomy, right? We're not going to be doing nasty interventions or super aggressive intervention on patients that is a futile intervention. But it has to be reasonable. In other words, the autonomy of the patient should not be interpreted in an absolute way, because many patients, they really just don't know. Okay, they may be afraid, they may be ignorant, with all due respect, so they have to be informed. But an autonomy, patient autonomy should be interpreted in a reasonable way. We know that ultimately they have the right to refuse even normal treatment as a transfusion. But when the patient is being unreasonable, one should engage with that patient in the best way, the most respectful way, to try to convince them that this is for the good, that they have a good prognosis, they have a very good high hope of continuing to live for many years with some kind of a treatment. And so patient autonomy should always be interpreted in a reasonable way. At any rate, these two documents are coming from the medical profession, POLST and MOLST, and like the word says, is physician orders for life-sustaining treatment or medical orders for life-sustaining treatment. Let's look at physician orders first. Physician order, this is basically kind of a pushback on the medical profession, on the healthcare profession, to try to reclaim some of their territory, some of their professional, medical, clinical territory, all right, that they really do know best. So go here for a moment. Let's look at, first let's look at POLST. And again, they go by, I believe it's by state. Anyway, what happens with post is that it is the physician basically is asking the patient ahead of time what options they want, but the medical interventions are limited to 3 possibilities. So if you think of a range of interventions, of a range of aggressiveness, right? It would be from the most aggressive, which is full treatment, to no treatment and just comfort care, all right? And so, and then somewhere in the middle. So those are the 3 possible options. And it's just distributed. It's kind of simplistic and it's a little dangerous in the sense that we never know exactly what we're going to need, what is our condition toward the end of our lives, or when maybe it's from an accident, or maybe it's from old age or a chronic illness. We never know, okay, beforehand. And so generally, we advised against signing a post. We advised against it because even though they can be revoked, it's kind of difficult. Once a post is in place, it has a lot of power of bite. It gives a lot of authority to the doctor just to go by what is in these checked in these boxes, either DNR or do not DNR, the 3 medical intervention possibilities, also nutrition and hydration, only 3 basic possibilities there, so on. Okay, so it's a little restrictive, or the whole thing about post is basically we just don't know what our condition is going to be when we need a medical intervention. Okay, so in general, we advise against signing a post. Now, the post, I do want to point out, has to be signed on the medical side, has to be signed either by an MD or a DO, all right, Doctor of Osteopathic Medicine, and therefore it's a professional who has gone through medical school or osteopathic school, right? So either an MD or a DO is the one that signs this form on the medical side, on the clinical side. And that's why it's called physician post. Most is even further out there, okay, in that it doesn't even have to be an MD or a DO. It could be a nurse practitioner, it could be an RN, or a PA, a physician assistant. Okay, so this one is even more, or takes over more of the patient's autonomy or decision making, because the most qualified healthcare provider can be a doctor, can be a physician, but can also be a nurse practitioner, can be an RN, or can be a PA, physician assistant, okay? So now you're getting into people who have somewhat of a less competency than an actual medical doctor, right? So this one is, we definitely counsel against signing a most. Again, because, well, so what it covers is pretty much the same categories as the other one. CPR, yes or no, medical interventions, full or least or intermediate, they're just reversed in the order, etc. Nutrition and hydration also here, advanced directives, if there are any. So the 2 forms have pretty much the same coverage, but at least with the post, you're actually, it's a medical doctor who's in charge. Here, with most, it may not have to be a medical doctor. It could be, like I say, a nurse practitioner, an RN, or a PA. So that's why, general in Catholic bioethics, we advise against signing these forms, because once they're signed and they're in place and they will go on the record of the patient and so forth, they're kind of difficult to remove or to rescind. Even though there's provision here for periodic review, there's even provision for review, okay? But sometimes this doesn't get done, or it's done incompletely, and the form is still binding. And what happens is now the patient is unconscious, so we go by the form, and they said DNR, so DNR. You follow? Okay. All right. So basically, that's what I have. All of these documents are in your Dropbox. Okay, not the Dropbox. Sorry. Yeah, the Canvas folder for Module 8. And yeah, so that's the end of this lecture on consent. So hopefully now you have a broader, deeper understanding what we mean by consent and advanced directives, etc., all the way down to these forms, and you'll see them around in clinical settings. Questions, comments? Nothing. All right.
Thank you, Professor.
Thank you,
Okay.
Professor.
Thank you.
All right, you're quite welcome. I'll see you Monday.
Mhm.
Okay, have a good weekend, sir.
Okay, you too. Bye-bye now.
Bye.
Bye.